Good afternoon, ACC New England members, and thank you for joining us for our webinar on employee non-competition and non-solicitation agreements. My name is Scott Connolly. I'm a partner in Verrill's Boston office in the Labor and Employment Group. With me today is my partner in the Portland office, Tawny Alvarez.
Thanks, Scott. Welcome, everyone. And I'd like to also introduce you to the third presenter in today's presentation, Joshua Wernig. He is Vice President and General Counsel of the Middlesex Corporation, and he's going to be providing insight from an in-house perspective as to so many of the topics that we're going to be discussing today. We have... Oh, sorry, Josh. We have a lot to cover, so we're going to jump right in. If during the course of the presentation you have any questions, please use the question and answer function, and we'll do our best to weave those answers into our discussion, or we'll follow up with emails afterwards.
We have four main topics on the agenda today: the contractual and procedural issues regarding putting in restrictive employment agreements in place, the steps to take when an employee leaves for a competitor. We'll also talk about hiring employees who are subject to a restrictive agreement. And then we'll finish up with recent New England cases and legal developments.
So jumping right in to putting restrictive employment agreements in place, there are 5 specific topics within this realm that we want to cover. The first question is, are non-compete restrictions enforceable? Then we're going to talk about when a non-compete agreement is appropriate. What is the proper scope of post-termination restrictions on an employee? Then we're going to consider what an employee receives in exchange for a restriction. Underlying all aspects of these employment agreements is the concepts of contracts. So we want to make sure that there is something being exchanged between the parties. And then finally, what are other important contractual provisions and process considerations that we should keep at top of mind? So we're going to jump right into, are non-competes enforceable? And of course, it's that answer you always get from lawyers, the answer that all of you give all the time: yes and no, maybe, sometimes. And when we give that answer, it's important that we look at it from 3 different perspectives in coming to the determination as to, in specific situations, whether the factual elements are going to provide us with an enforceable non-compete agreement. The first one is looking at it from the employer's perspective. So as each of you are working side by side with the leaders of your organization, some of the things that we want to keep at top of mind when we're considering whether or not an agreement works in this situation is, are we granting the employee access to customer relationships or confidential and proprietary information? If so, that's going to support enforcement of a non-compete agreement. Do we have, as an organization, a need to protect legitimate business interests from unfair competition from other individuals? Are we in a position that can be undermined by selective enforcement? Are we an organization that requires every single employee who joins our organization to sign a non-compete agreement, but then we only enforce it against our C-level team members, or many of our employees don't receive any confidential information despite the fact that we're asking them to sign one of these agreements? So consider your history as an organization, whether or not you've selectively enforced. Also, the position can be undermined if the employer does not take proactive measures to protect information that it considers proprietary and confidential. If there's not locks on files, on physical documents, those type of things, that's going to decrease the enforceability likely of a non-compete based off of this idea of confidentiality. Josh, what are some of the other things that you're going to be talking to your leaders about as you're talking about the enforceability of a non-compete?
Yeah, I think it's a great question, Tawny. And sometimes I even start with a more basic question: is it important, whether it's enforceable or not? Are there other considerations of why you're putting non-competes in place? Are you just trying to get it enforceable enough so you can get a toehold into those conversations and and protect your interests in a greater perspective? But also, when you're looking at that, and I think you started to touch on it, talking about protecting legitimate business purposes, you really want to look at, what restrictive covenants are out there, whether there are less restrictive covenants that might make more sense, from that perspective. So I think us, in-house counsel really need to get with our business partners, and we need to be talking to our CEOs and COOs, understanding the intentions, what's important, understanding the business needs of the company, to truly understand the legitimate business interests or the confidential information, or getting to the basis of what might be important, to protect. So I think it really is trying to become that new age in-house counsel where you're really more of a business partner embedded, and to talk about some of those different concerns.
So now that we've seen it from the employer's perspective, in my mind, it seems like, well, of course, non-compete should then be enforceable if we've looked at all these factors and we've taken it into consideration as we've drafted the document. But then we need to weigh some of the employee's perspective. So will it impede the employee's ability to make a living or seek new employment? Are you in an industry or an area that will significantly limit future employment as a result of the non-compete? Does the restriction extend beyond any form of severance pay that may be offered, or garden type leave generally? Often, is there any real threat posed by the employee's activity? So we're going to look at that. Is the information within your organization stuff that is generally known within the organization, and that you're not really losing confidential and proprietary information to competitors? And then we're going to look at state and public policy concerns. So restrictions on free competition are disfavored. They're subject to close scrutiny. And when we get into each of the states' review of this area, it's very state specific. And then concerns over unequal bargaining power generally, especially right now in the midst of COVID. At the end of the presentation, we're going to focus on that even more.
We're going to talk about the three main types of restrictive covenants or agreements with employees. And the first is obviously the broadest type of protection for employers. A non-competition or non-compete provision or restriction will prohibit an employee from working for a competitor for a period of time in a geographical area after termination of employment. Going back, the first thing to consider with non-competition agreements, as we've all heard, are the changes in the laws that states are implementing with respect to non-competition agreements, which have often been viewed as unfair to certain categories of employees. Many of you are obviously aware that California has banned non-competition agreements outright. Oklahoma and North Dakota have similar bans on non-competes. And then many other states have taken a mid-level approach and restricted non-competes with low wage earners: Maine, Maryland, New Hampshire, Washington, Rhode Island, and Virginia. But the general black letter law for non-competes is that they have to be necessary in the first instance. They have to be necessary to protect legitimate business interests. And courts have, in the common law, courts have recognized basically three types of legitimate business interests: trade secrets, intellectual property, confidential business information, and then customer goodwill, being the expectation of repeat sales or business with customers. In addition, courts will look at whether the restriction is narrowly tailored to protect those interests or reasonable in duration, geographic scope, the activity restricted as well. And one important point to remember is that when you're looking at your contracts, several recent cases have differentiated between preparing to compete and actual post-termination competition. So in reviewing contracts as an employer, you want to make sure that taking steps to prepare to compete is covered as prohibited conduct under your agreement. The next type of restriction we'll talk about is non-solicitation, and it can come in two species. One is a restriction on soliciting customers post-termination, and the other is a restriction on soliciting employees to leave the organization. Courts and businesses often struggle with the concept of what constitutes solicitation. It was clear before all of our recent technological innovations when a customer would physically call on a customer location, and that clearly was solicitation. Generally, courts look at how targeted the message is to determine whether there's been encouragement or inducement or an enticing away of the customer relationship. Generally, the cases have been looking at things like updating LinkedIn profiles as being not sufficiently targeted to constitute solicitation, whereas a targeted email announcement of the employee's new position would be something that piqued the customer's interest and incited the customer to make the initial contact. And that's a case out of the First Circuit. That language is a case out of the First Circuit called Corporate Technologies v. Hartnett from 2013. And there, the email blast was targeted to a group of potential customers. It announced the employee's new position with the new employer, and 40% of the recipients were customers of the prior employer. And that was obviously not a mere public announcement of the move.
Josh, a lot of the agreements that we're seeing lately include actually specific carve-outs saying updates to LinkedIn or those type of things won't be seen as solicitation. Has that changed, seeing that type of language in agreements when you're hiring someone or including it in your own agreements? Has it changed how you're marketing or working with your marketing team or your HR professionals regarding what could be considered solicitation in the future?
Well, it's certainly something to take into consideration. I mean, first of all, you have to be a good partner, and you have to have a good relationship with your HR team. So they, first of all, need to identify any restrictive covenants that are coming into play, for incoming onboarding new team members. So, understanding those, taking a look at those, making sure they know when to reach out, to the in-house legal team and/or the in-house legal team understanding when to bring in, strategic business partners such as Verrill, into the conversation. But yeah, I mean, you want to understand what those restrictions are. You want to understand, incoming, but also what's your strategy? And, I know we're starting to touch on this to some degree, going through the different types of restrictive covenants here, but, you really have to take a look at, what's appropriate for the right class of people, and look at, the types of restrictive covenants there are. And I know we're going through those now, but what is appropriate for which level of individual. Now, what's appropriate for some of the lowest level workers in your company won't be the same for some of your mid-level salespeople, or in construction, which I'm in, my pre-construction team that is estimating bidding new projects, and certainly that's different for what's acceptable for the executive C-suite level individuals as well. So I think all of that comes into play. You need to understand the language of any person that's applying. And I think it does affect how you want to narrowly tailor, because you want these provisions to be upheld, or at least to make it past the initial TRO stage if you're going to be looking to enforce and such. So I think that it all does come into play and needs to be considered.
So as we're talking about the type of restrictions, I mean, a big one that's usually at top of mind and the employers use with all levels of their organization is a confidentiality agreement. Oftentimes we'll see in employee handbooks a provision regarding confidentiality and a reminder to our HR team that that in and of itself does not kind of hold any weight. In most cases, the handbook's not a contract. So while you can have a confidentiality provision within the handbook, that's not the confidentiality that we're talking about. We're talking specifically about a contract that you're going to ask each of your employees to sign. It's important that you define the confidential information and you tailor it to businesses. I think what Scott and I see a lot of times is employers coming to us with a confidentiality agreement that's maybe 12 pages long because the definition of confidential information takes up, 2 to 3 pages. When we find out that it's a 10-person organization, a definition of confidential information does not need to cover everything in the world. I know that's hard to believe since we're lawyers and we tend to try to cover all of our bases, but we do need to make sure that it's specifically tailored to the organization itself and the confidential information that is going to be at issue.
Yeah, and Tawny, just to jump in there for 1 second, not only to the business itself, but to the business unit. Now, I think one error I think that we can run into is in some of these larger organizations is maybe not thinking about we don't want a one size fits all. What's right for my pre-construction, my bidding team may not be right for somebody that's in the C-suite, right? Or may not be right for somebody that might be dealing with accounting and other information. So you want a cadre of really of good templates, in your system, especially if you're a large organization that might have separate business interests and separate business units to consider.
Absolutely. And I think that goes directly to third-party information as well. If you have members of your team who are not going to have access to your customers or clients' confidential information, inclusion of those type of provisions in a confidentiality agreement doesn't make a ton of sense. But if you have a sales force or if you have individuals who are working with third parties and are receiving their confidential information, making sure that you're protecting that information is also important. Something else that I think comes up a lot is whether or not you have a limitation as to time. Is your confidential information going to be confidential forever? Is there certain aspects of it that will expire and won't be confidential at some point in the future, or that will be irrelevant at some point in the future and therefore, maybe was confidential, but in 5 or 10 years won't be? So consideration as to time is important. And then something that's come to top of mind as a lot of us are working from home, and as you can see, most of us are, the protection and storage of data and documents, especially in a remote work environment. And as we're letting go employees or we're seeing terminations, how is that property going to be returned to us? Oftentimes it'll say that the individual's required to destroy it, but if they're required to destroy it, does that violate any document retention or destruction policies that you have in place? Making sure that this agreement corresponds with other agreements that you've entered into or policies is so important.
And
Josh,
Tawny, I'm really glad you brought that up. And I think with this new world, with COVID and with all the complexities and people working remotely, I think that, even more attention needs to be brought to, understanding your IT systems, understanding the capabilities, and oftentimes I think that we overlook that and we don't think about, and sometimes your own IT departments don't fully understand, what systems may already be in place, what you already might own, but you should be sitting down as in-house counsel, talking to your IT, department and your subject matter experts to really understand. Just because you're working remote, just because people have remote laptops and such, doesn't mean that we don't have security and compliance centers through Office 365 or other means and methods and audit logs in order to employ. And sometimes it's a matter of just understanding what they are, understanding the purpose, and understanding to make sure put those safeguards in place so you can determine whether there's been any breaches of this. Because not only on the backside determining whether there's been a breach, but I think, you need to have those measures and reasonable, measures in place in order to continue to protect the confidentiality and meet the reasonable standard of making sure that you're protecting your data and taking that affirmative action.
Absolutely. So some consideration issues, we talked about that right at the beginning, about the fact that this is a contract, which means all the contractual elements that we normally would see would come into place, including consideration. Now, consideration is going to be state specific. So you're going to check, is starting new employment going to be sufficient consideration? Is continued employment consideration? The timing of when that agreement is provided to an employee is going to play a role in that. Is there an increase in compensation? Is there direct money being provided in a bonus format to the employee as a result of them signing the agreement? Keep all of these things in mind and be mindful of where the employee is working out of, because that's the law that we're going to be reviewing in determining whether or not sufficient consideration has been given to create an enforceable contract.
We're going to talk about some important process and contract issues. And the first one is advance notice to the employee of the requirement to enter into these restrictions. I know that in Massachusetts, there was a 10 to 15 year effort, legislative effort to curtail what was seen as some procedural unfairness and other types of unfairness to employees and imposing non-competes and other restrictions on them. And one of them was the idea of an employee receiving for the first time the non-compete to sign after they've joined the employer. And so you want to think about providing advance notice to the employee and even including disclosure of the requirement to sign a non-compete, non-solicitation, or confidentiality restriction as part of the interview process. And that's the best way to do it in Massachusetts, which requires specific advance notice of the requirement to employees. Many of the state legislative efforts focus on advice of counsel, requiring in the contract or agreement the employee to seek the advice of counsel. And this may impact the perception of fairness when a company later seeks to enforce the restriction. Many of you have seen in non-compete agreements language to the effect that the agreement will follow the employee throughout changes in the employment relationship, promotions, demotions, etc. This comes from a line of cases that's been adopted in many jurisdictions that establish a material change doctrine. And the concept is that when an employee's job changes such that in reality a new employment relationship is created, it's fair to expect the employer to seek to impose a new restriction on the employee. And it's very common now for employees challenging the enforceability of the non-compete agreements to challenge them on the basis that that they've undergone a change in the employment relationship and the employer didn't take the step of putting a new agreement in place. Therefore, they're not bound by any restrictions whatsoever.
And Scott, I think that's an important, piece to kind of underscore. It's just so important to, as you go through the process, as you're looking at these different restrictive covenants, making sure that whatever process you put into place, that you're reviewing these agreements on a regular basis. You're working with your HR department, who's normally or maybe more naturally managing the process and making sure that they're aware, to institute, whether there is a material change, maybe that's a time to revisit and put another agreement in front of somebody. And also maybe as you look to what different types of restrictive covenants might be appropriate, if somebody's going from a lower level where you might just have a confidentiality, and you're going to a higher managerial level where you really want that non-solicitation, protection as well, that's an opportunity. and an opportunity to make sure you can get beyond some of these material challenges, but also, to make sure that you're appropriately readjusting for the new role.
Thanks, Josh. Blue penciling is the ability in the contract to carve back or narrow any provisions that a court may find to be too broad. And in other common contract provisions that you'll want to look carefully at are choice of law, choice of jurisdiction, attorney's fees, tolling, and assignment. Choice of law and choice of jurisdiction are factors to think about when you're really thinking about your enforcement practices, especially if you're a multi-state or multi-jurisdiction employer. Thinking about, if we have employees in California or other states that ban non-competes, what's our enforcement practice going to be? Are we going to try to seek to enforce these agreements in Delaware? What are the implications on that? And what do we need to have employees do when they're signing agreements?
That's a great point, Scott, as well. I think when you're really looking at that choice of law provision, you really need to get into the specific requirements of every state. And, certain states like Massachusetts, you're really going to need to file that, in the county where that individual is domiciled, where that employee lives, and or Suffolk County. So I think that understanding that, whereas Connecticut, you might have a little more leeway since they don't have any statutes necessarily that really are on point here. It's more case law specific, but when you're defining the choice of law and jurisdiction in your agreements, it's important to take into consideration all the jurisdictions you work within. Whereas you might have a Massachusetts, you might be like my company, we are incorporated in Massachusetts, and we do a lot of work in a number of jurisdictions, including Connecticut and Florida. Where my Massachusetts agreement might be enforceable in Connecticut, where I might want something different in Florida, given the state of the law down there.
Some additional and recently highlighted process and contract issues include making sure that signatures are obtained on non-compete agreements. In Massachusetts, you now have to obtain the agreements have to be signed for non-competes by both the employee and the employer. Storing signed agreements in a secure place. I call this sort of avoiding unpleasant surprises. When your client sends you an agreement that's unsigned and you ask for the signed one, and a search of HR files doesn't turn up a signed agreement, and then you're left to be alleging violations of the common law.
Scott, I think that's such a great point. It can't be underscored enough. You can't assume, unless you've had those affirmative conversations with your HR department and understand those processes. I mean, in-house counsel is really expected to be that business partner nowadays, and you really have to dig deep and spend some time, with your different departments and whoever's managing this process to understand and make sure they understand, the basics that you're going to need. And it sounds so basic to talk about obtain signatures and store them in a secure place. But, there are occasions where those issues come up and then they look to you as in-house counsel, hey, fix this. Well, it would be better if we fixed it up front and had those affirmative conversations and show that due diligence on the front end.
And I think we see this even more when we're talking about remote work situations where someone is PDFing a document back by email and HR or another team member is presuming it's signed and maybe doesn't scan all the way through it and just saves it into the file thinking it's signed. And maybe the employee meant to sign it, but the signature is not affixed right or something like that. Even just scrolling through the whole document to make sure it's there is so important.
Just wanted to highlight in the sale of business context is different. So to differentiate between non-competes in the context of the employment relationship versus sale of business agreements obviously can be much longer. So it's an important concept to be thinking about in the context of a corporate transaction where owners or executives may also be participating in the sale, in which case, longer restrictions can be imposed. In addition, many states have exceptions that render non-competes unenforceable or void against certain types of professionals. Physicians in the practice of medicine is an example in Massachusetts.
Next, we're going to jump into steps to take when you know an employee is leaving for a competitor. So 4 main things we're going to talk about in this section. First, the exit interview, reminding departing employees of their continuing obligations in the future with their future employer, and also collecting information. As much information as we can collect will be helpful for us moving forward. Time is of the essence. We're going to assess the situation quickly. We're going to consider cease and desist letters and whether or not that's going to achieve the desired result, or if filing suit, TRO, preliminary injunction, permanent injunction, and then our ability to prove damages generally. So we're going to run through all of that. First, assess the threat. So gathering information is so important. I'd rather HR professionals ask the question and the employee refuse to answer than to be on a call and saying, well, what about this? Or do you know this? It's easier for the employee or HR to say, we asked and they refused to answer, those type of things, than I don't know, we didn't ask, I don't know. Next, employee deception or lack of forthrightness. We've dealt with cases in which multiple individuals who have said, you know, I'm going to step away from work, I'm going to focus on family, or I'm going to focus on a family business. Come to find out, however, they're moving across the street to work for a competitor. This is one of the times where hearing what's going on in the rumor mill or around the water cooler sometimes is really helpful, because it's hard for that deception to spread to every kind of level of the organization. In a lot of situations, when we're discussing litigation about non-compete issues, come to find out as we start gathering information, half the staff knew where the person was going, but leadership thought that they were going elsewhere because of some lack of forthrightness. So making sure that you're finding out as much information as possible. Computer forensics, as soon as you get information that the person's leaving, if you know they have confidential information, track what they're sending themselves, track what they're sending other people, track what they're downloading off the system. Are they accessing files that they don't have the right to be accessing? Those type of things are really important. And either having someone in your IT department who can do that, or having a third-party contractual relationship that's going to be of assistance. And then also training managers not to unknowingly give waivers or say, yeah, that's no problem for you to have that, or yeah, don't worry, or we're not going to enforce that. I've had situations where managers said, oh, don't worry, that's not going to be a problem if you go there. And they haven't talked to other business partners or leadership about, you know, why they're saying that. Josh, in your experience, kind of how do you deal with that with managers more generally and other partners?
Well, I think there's a lot to unpack with what you were just talking about here, and I'd kind of like to go back to, first of all, to gathering information, you know, and I think we sometimes take, you know, this actually rolls into training managers as well, the whole training aspect and being upfront and having a plan and making sure that this is a thoughtful process, and that whether you have the resources internally within your legal department, or you find strategic business partners like Verrill, you know, to come in and help you determine what your policies, practices, and procedures and templates are. But gathering information, do your people, who's going to be responsible for this? Are they up to the task? Do they know? Do they have a process? Do they have a checklist? Do they have a process in place that's replicable and that they can do, and that will produce the results that we as in-house counsel or as outside counsel recommend? So I think that's important to take a look, you know, on the front end, about making sure that there's a thought process, that there's some checklists. I know the ACC resources library online, you know, it's available to all members. It has some great resources. I've used that quite a bit in developing different checklists and different information for my HR department, you know, when they're managing this, but also not overlooking the training and making sure that we don't just leave that to the HR department or to another department, that we as in-house counsel get in there and make sure we're taking a look at the substance and information and making sure that, you know, if we're not providing that training, but making sure that we have our fingerprint on that to make sure, you know, that is being done properly and adequately to get the results we want, because you certainly don't want the frontline managers, you know, to have those ability to have those failure points. And I think those are all, you know, very important pieces. And oftentimes it's the planning up front. It's thinking about it before these become issues. And Tawny, I know you and I were talking about before we got going this morning, you know, just about sometimes the experiences and what you run into and getting bit by these issues sometimes is the greatest teacher. But spending the time up front, learning from other people's experiences, you know, talking to your colleagues, talking to, you know, Tawny and Scott or others, you know, about, you know, what they see in the case law can really get a clever and good plan together where you might not have to go through some of the hard experiences to learn those lessons. The other piece, yeah, you know, it's so important. And the other piece,
they're hard and expensive. So they're not just hard; they get expensive.
And I've learned those lessons the hard way as well. You know, and it's just something that, you know, it can be an impact to the company, can be a huge distraction also, especially for a small legal department. You know, even if you have outside counsel involved. It can be a huge distraction and a huge detraction from really, you know, moving the business forward. The other piece I just want to just touch on, because I'm glad you put it in here, is the computer forensics and text and email activity. It is bizarre what you see people actually doing and willing to do. And sometimes just asking the question of your IT department, hey, IT director, can you just go in and make sure there's nothing unusual? And sometimes it comes back and, like, you know, I think I was sharing a story, but not from my current employer, but when I was with another company, we actually found a video of somebody with their iPhone taking a video of confidential information that he emailed to himself from our computer system. He took the step to try to bring it outside our computer system so he wouldn't get caught, but then he emailed it by putting it back. It was bizarre, but that stuff happens. People are not overly sophisticated when they're trying to grab and smash and take some confidential information on their way out the door. So sometimes just those quick conversations, if you have a key employee that has access to key information, or that you found out is going to a key competitor, that might even raise just some question that you might want to just ask that question and see if there's anything unusual.
Next, we're going to talk about cease and desist. Now, in a lot of situations, a client will say, let's just send a cease and desist. We'll scare them. You know, I'm not going to want to move forward with this. We'll just scare them. That'll be sufficient. Be mindful that a cease and desist, to be effective in most cases, isn't just going to go to the former employee. We're also going to want to send it to the current employer. We're going to want to put the current employer on notice that these obligations exist. But in doing so, there's a chance that we're going to be seeing either a counterclaim, or if it's a race to the courthouse, a claim of tortious interference with a contractual relationship, something along those lines. So keep in mind that while a cease and desist seems as though it's a really kind of light touch way to show force, maybe without an intent to file suit or go through a TRO or a preliminary injunction, there are ramifications even to that small step that you want to keep in mind. And having, I mean, when we're talking about computer forensics, we want to have that data available to show that the employer has in some way violated either the solicitation, the confidentiality, some aspect of our agreements, and having that physical proof, as opposed to Sally told Bob that George did this. You know, that's not going to be as helpful as us having some computer data or information showing information was stolen, or that they've gone directly to work with a competitor.
And Tawny, and sometimes it's just finding evidence that of the appearance or the optics of that occurring, which can give you enough to, you know, to really make some hay out of it. But when I talk about cease and desist, sometimes I want to talk about, you know, in a more initial step. And I know you guys kind of covered this previously. when reminding people during exit interviews of their continuing obligations. Sometimes when key individuals will leave, I not only remind them during the exit interview, but sometimes I'll take the extra step to send a continuing obligation letter, to put them on notice before you even have to get to a cease and desist. And, depending on the situation, you might consider sending that to the new employer as well, just reminding them about the continuing obligations that your key member that might be leaving might be under. And then certainly when you start considering cease and desist, I think Tawny is absolutely right. You really have to consider, the full ramifications, implications of that. Excuse me. But sometimes having a conversation with your CEO or COO can also be helpful. Sometimes there's business relationships on the business side that your CEO or your COO might have with your key competitor that your employee might be going to. There might be ways to get around the need to go to court in business concerns and business conversations that can be had, that can put some of these issues to bed.
And then if we do have to go to court, we're going to be looking at temporary restraining orders, motions for preliminary injunction, or whether or not we just file a simple complaint and wait. When we're talking about a TRO or preliminary injunction, we're going to be talking about likelihood of success on the merit. Is the contract provision going to be upheld? What irreparable harm are we experiencing and how can we prove it? And then whether or not the harm to us outweighs the harm to the former employee is important. And then the public interest. And the public interest in most situations is going to weigh in the employee's favor. But oftentimes when clients come to us and say there's been a violation of one of these contractual provisions, the biggest thing is for us attempting to prove this irreparable harm and understanding the importance of having that data pulled and available and ready. I don't want to say at a moment's notice, but fairly quickly. It is more helpful for us in preparing and decreasing the costs associated with what can become a really costly process through the preliminary injunction process. Josh, other things to add in preparation for those type of activities?
Yeah, I think you hit the nail right on the head, Tawny. And I think, our role as in-house counsel, my role, is often to, make sure I'm the business partner, understand, what my HR department is doing, make sure I get in contact with IT, kind of be that quarterback. But also, if we're going to be moving to a TRO or moving for preliminary injunction, I think you're absolutely right. We want to make sure that we do it timely. Making sure you get your outside counsel lined up as soon as possible if you don't have the ability to push that forward in-house. So I think it's having those relationships and the outside counsel understanding your business and understanding how you operate and I think can be critical as well to be that have them ready to go at a moment's notice.
Okay.
Let's
I'm sorry, everyone.
let's change perspective now and think about these issues from the point of view of wanting to hire a key employee who's subject to a restrictive agreement. I know all of us have been in that situation where the business people come to us and say, we want to hire this employee from company X, but we found out that they have an agreement. Here's the agreement. Is it enforceable? And that's sort of always the threshold question that I'm presented with by business people is, is this going to hold up, this agreement? And I often say, well, it's not really the relevant question. We want to understand what we're doing is trying to predict the response and predict often human behavior. And to make that assessment, we obviously want to look at the agreement and whether maybe it's overbroad or even unenforceable under particular state law. But we want to look at the competitor. What resources can the competitor bring to bear? What's the situation? Have other employees left recently to join us? Is this the fifth hire that we've made from the same company recently? That might predict an aggressive response from the prior employer. We may also want to look at what prior types of lawsuits has this competitor brought to enforce a non-compete agreement. So In other words, what's their appetite for engaging in expensive litigation? You know, frankly, often it can be a question of finding out, you know, how valuable that employee was to them, and whether, for instance, there's personal animosity. Did they leave on bad terms or good? You know, is the former employer's CEO very upset with the employee for leaving? And those are things, you know, we want to really push at with the employee to assess, you know, whether we as the new employer are going to be embroiled in the lawsuit or the dispute as a defendant with tortious interference claims alleged against us.
Yeah. Scott, I can't agree more. I think you've hit it right on the head. These are often business decisions. These aren't necessarily legal decisions that we're making. You know, what level of risk is your corporation willing to take? What's the response from the former employer? And I think you need to weigh that with some of the enforceability pieces. And, you know, even if things in the end you might prevail, it's going to be costly. It could be distracting to go through, you know, a messy fight. But, you know, you need to assess all those pieces to know really what the appetite is, and then what mitigating pieces can you put into place to ensure, you know, maybe you address some of those concerns proactively, you know, putting them in a different region or putting them in a different role that might not be directly competitive, you know, immediately with some transition period.
Agreed. And one threshold issue is whether you're going to want the employee to have separate counsel immediately, or whether, you know, the company is going to agree to indemnify and pay the cost of defense if there is a dispute. And, you know, one issue there is really grappling with sort of, you know, what's the likelihood of unknown facts? You know, are we going to be bitten by the revelation that this employee who we've, you know, come to trust and have confidence in and want to hire, you know, perhaps did things that make him or her look like a bad actor, like taking materials and data on their way out the door. So, you know, we definitely want to sort of poke at that and find out, you know, whether we know all the facts.
Scott, I would also just add, you know, oftentimes the CEOs and COOs have relationship with some of these other companies, you know, at their own level, and sometimes it can be very helpful just to open up business conversations as well and get some understanding, you know, through those channels.
Yeah, it's great when a departing executive or key employee has counsel who can tell them, look, be very conspicuous with your return of your former employer's materials. I give that speech countless times. Is you know, you don't want to do anything for which you could be portrayed, you know, even mistakenly, as someone who's taking things that they shouldn't be. And then in hiring an employee who's subject to an agreement, you want to be thinking ahead and making sure that you have a good contract language in your agreement or your offer letter that makes it clear that you don't want any materials from a former employer and that the employee is prohibited from using them. You know, in your defense of a case, you'll be advancing that. Look, Judge, you know, we say it in our contracts with the employees. We take steps to make sure that they don't bring anything with them in terms of confidential information. We don't want it. We're not going to use it, and you know, we make them promise not to do that. And seeking and trying to get waivers can be, you know, one consideration, one plan of action. It's they're not always easy to get, because it's easy for, you know, a company to say no, but it does start a dialogue, and you want to be thinking about, you know, what assurances can we give of non-competitive activity to the former company. You know, we're going to make sure that the employee is promised, and we're promising not to use or disclose any of their business information. And as Josh mentioned earlier, you know, can we place this employee in a non-competitive capacity until their restriction runs out?
Yeah, I think that opening up the channel for those business discussions can really pay dividends. You know, like I said, you know, these are business decisions that are informed by legal implications. And so we really want, as much information and as much ability to resolve these on the business side of it, with good advice from good counsel.
So we are going to run through recent developments in New England generally and in the next 11 minutes. So we're going to really run through that quickly, but all these slides are going to be made available to all participants. So don't worry about that. Everything on here will be provided.
So it's been about 2 years since Massachusetts passed the Non-Competition Agreement Act, which was the product of about 15 years of legislative back and forth over whether there was going to be a ban, an outright ban on non-competes in Massachusetts, like California, or lesser restrictions on the use of non-competes, and sort of that's what's happened. On October 1st, 2018, the Non-Competition Agreement Act went into effect, and it established several requirements for an employee non-competition agreement to be valid and enforceable. Importantly, the law doesn't even apply to non-solicitation restrictions or other types of agreements, and customer and employee non-solicits, NDAs, non-competes in a separation agreement. So as long as a separation agreement has a 7-day revocation period, there can be a non-compete restriction in there, and it falls outside of the Non-Competition Agreement Act. Like the other states I mentioned, it restricts the use of non-competes with low wage earners and student employees. One of the biggest issues in Massachusetts was the language of the statute that ultimately was adopted, which was a product of 15 years of legislative back and forth. It's a statute, obviously, that came out of committee and compromise, and there's a reference to garden leave being provided or mutually agreed upon consideration. And there was a lot of uncertainty when the law was passed as to whether garden leave was required. And I'm of the view that the consensus now is no, garden leave is not required. And I never wanted to use garden leave because the statute requires it to be paid in accordance with the Massachusetts Wage Act, for one thing, and that sets up claims for treble damages under the Wage Act for non-payment. So I always wanted to avoid that and use some other mutually agreed upon consideration, which I think the consensus now is that for new hires can be the offer of new employment. But I still try to carve off some of the consideration that's being offered as specific consideration for the non-compete, like a grant of options, a sign bonus, an annual bonus, etc.
If we jump into Maine, so Maine's non-compete statute went into effect September 19th of 2019. There were two specific provisions. One is 26 MRSA section 599A, and that's directly related to non-compete agreements. And then section 599B deals with restrictive employment agreements. So under the non-compete agreement statute, it must be used to protect goodwill, confidential information, and trade secrets. So it can't be, it must protect more than that. So if a confidentiality agreement or a non-solicitation agreement could accomplish those goals, then a non-compete wouldn't be appropriate. So we really want to make sure that the language is talking about goodwill, customer relationships, those type of things. It's only enforceable if the employee's wages are 400% above the federal poverty level. So the individual needs to be making over $51,040. It needs to be disclosed to the employee prior to the offer of employment, or if there's a change in the employee's responsibilities that's resulting in the non-compete being required, then a copy of the agreement must be provided at least 3 business days before the individual is going to be required to sign. And even if the employee signs it and they're making over 400%, they've been provided with the appropriate amount of time, that agreement is only going to become effective if the individual has been employed for at least 1 year with the organization, or 6 months from the date in which it's signed. So if an employee's been employed for 3 years and then they sign the agreement, we're gonna have to wait at least another 6 months until it becomes effective. So you can't have an individual sign a non-compete agreement and then the next month terminate them. As to Section 599B, that forecloses agreements between two employers to restrict their ability to solicit or hire another employee. So we saw a lot of this in California in the tech industry. And generally between franchisees and franchisors was another big aspect of it. And also you can't enter into or threaten to enforce restrictive employment agreements. So right now we don't have any case law that is interpreting any of these statutes. So stay tuned in the next couple of months and years to see how some of these terms are going to be reviewed.
We'll move along as we have about 5 minutes left, but Connecticut generally follows the common law principles we talked about earlier, allowing non-competes if they're necessary to protect legitimate business interest and reasonable in time, scope, and the activity restricted.
New Hampshire has a statutory provision that went into effect a few years ago. The important thing to note here is that the agreement must be provided to the employee at the time of the offer of employment, which is something that we discussed. And again, similar reasonableness standards as to what we've discussed previously. In Vermont, we're not looking at a statutory provision, but we're going to take into account all the things we've previously discussed regarding legitimate business interests, not unnecessarily restrictive to the employee, and doesn't violate any public interest.
In January 2020, Rhode Island passed a law regarding non-competes that's very similar to the Massachusetts law. In fact, it copies some of the language directly. Importantly, it's limited as to low-wage workers who make less than 250% of the federal poverty level. It restricts non-competes for employees who are non-exempt under the Federal Fair Labor Standards Act, undergraduates and graduate students, and those 18 years old or younger. Stay tuned for possible federal rulemaking in the area of non-competes. In January of this year, the FTC held a public workshop, and there's been, federal legislation proposed to address the use of non-competes in employment contracts nationwide. So we'll see whether those efforts bear fruit or not. And in California, as we talked about, non-competes are void and unenforceable by statutes, and probably non-solicitation agreements too, although there's been some back and forth over the years about that. There was a 2018 appellate court decision in California refusing to enforce non-solicitation under the statute. I did want to point out one wrinkle in California that talks about its labor code section 925. It says that an employer can't force a California employee to accept a non-California choice of law. And this is aimed at, that choice of law, choice of jurisdiction consideration where, some companies will try to enforce non-competes in Delaware against California employees or states where they're headquartered, have their principal place of business. And interestingly, the law has an exception for employees represented by counsel in negotiating the terms of an agreement. And I've had situations firsthand where a large national employer required an attorney to review their employees' non-competes because part of their enforcement practice was to take advantage of this exception under California law that would allow choice of law, choice of jurisdiction outside of California.
Would any presentation be complete if we weren't talking about the role COVID plays? So consider the fact that we're still looking into, and we haven't had a bunch of case law yet as to whether or not acts of God may invalidate contract clauses, and that may include some of these employment provisions. If we're dealing with essential employees who have non-compete provisions, consider more the public policy related to it. If you've terminated that individual, you've forced unemployment, you're creating an undue hardship kind of for the world. If there's a need for this essential employee, but you have a non-compete in place, that can become problematic. Also, consider if right now you're relaxing your enforcement, can this behavior be used against the organization in the future? Or is there really a legitimate interest in having the non-compete in the future if during this time you're not enforcing it? We have seen one specific case at this point in time out of the Eastern District of Pennsylvania, the finding that a layoff was a termination, and within the terms of the contract itself, the non-compete provision wouldn't be enforceable if the individual was terminated. So the layoff was considered a termination. But question, if you furloughed an employee with a non-compete and that furlough later turns into a termination, does the non-compete period begin to run at the time of furlough or the time of the non-compete? So those are things you're going to want to keep in mind. We've got one final slide.
And we want to leave you with some key takeaways from today's presentation, and obviously that will be that non-competes will be scrutinized closely by the courts, and may not be enforced or enforced only narrowly, and to be advised about changes in state law. Number two, many but not all of the goals of non-competes may be achieved with non-solicitation confidentiality provisions. I say but not all because one consideration is having non-competes in your agreements in the context of due diligence in a corporate transaction. So you may be involved in the sale of a business where the lawyer is doing due diligence for the buyer, or from, for example, outside of Massachusetts, and they may, be looking for non-competes to be protecting the interests that they're going to be purchasing. So that's one reason why non-competes can be important, even though non-solicits and NDAs can do the job. Three, cases often turn on a clear showing of threatened irreparable harm and perceived bad acts. And we've probably all seen those cases that involve theft of materials and direct solicitation of customers. And lastly, all competitive new hire situations should be reviewed for the risk of prompting a non-compete dispute before you're involved in one. Really want to thank you for joining us today on behalf of myself and Josh and Tawny. Thank you very much.